Good afternoon. Keep eating. I'm Steve Sussman with the Civil Jury Project at NYU Law School. And now this is like our 28th lunch like this across the country. So we kind of have a routine, which is to begin the program very quickly so we can end promptly at 1:30 and let the judges go back to their, hopefully, jury trials. But in any event, we will stop at 1:30 today, and we have a lot of judges and 4 jurors who are the ones we mainly came here to listen and learn from. The Civil Jury Project was started at NYU School of Law about 3 years ago as the only academic center in the country which was devoted to asking the question, why are jury trials disappearing? Do we care? And if so, what, if anything, can be done about it? Obviously, jury trials were quite important to our founding fathers. The idea of a jury trial is mentioned 5 times in our founding documents, in the Declaration of Independence, in the Constitution, and in 3 of the Bill of Rights. Jury is so much part of our system of justice in this country that, and keep eating. Well, I know I'm interrupting your lunch, and don't keep eating, and dessert's going to be put on your table. That there's not a courtroom in the country that doesn't have a jury box. It's just part of the DNA and the architecture of our justice system. But the unfortunate fact, which is indisputable, is, and this graph illustrates it, is for the last 55 years, jury trials have been vanishing. And we are now down to the point last year where the average federal judge in this country tried only 2 jury cases, civil jury cases, and as this indicates, because the red is jury, the blue is bench trials. Bench trials fared worse than jury trials. Now that should tell us something about, actually we could have called the center the Civil Trial Center, because something is happening in this country to public dispute resolution, whether it be by a judge sitting alone or with presiding over a jury trial. And if someone looks at these figures, and the trend is, it's still going down. And you say, well, maybe it's because there are fewer cases being filed. And if you look at the statistics in California, the average per judge, authorized judgeship was 1.6 in 2018. In bench trials, 0.4. And the Northern District of California does not rank very high in the country, 60th in terms of the most jury trials per judge. This is the graph I was looking for, which is the percentage of civil cases that are terminated by bench and jury trial. And you can see what's happened to it since 1962. The same trend line, a drop. If you look in the Northern District of California, the percentage of cases resolved by trials has gone up and down over time, but largely trending downward. The state court in California seemed to holding level, but still only 0.2% of cases today are resolved by jury trials in the state of California. So it's obvious that we are losing a trial by jury. One of the things we have done at the Civil Jury Project is go around the country when we began and see whether we could get judges to help us reverse this trend. we now have 290 state and federal judges across the country that are judicial advisors to the Civil Jury Project and that are helping us reverse this trend. In addition, we have about 65 law professors who are academic consultants working on various empirical studies on jury trials. And we have today 42 jury consultant advisors, one of whom, Judy Rothstein, who's a jury consultant in Davis, California, is here with us today and will help me moderate this program. We have put on lots of lunches. As I say, this is our 28th. We have 4 or 5 more scheduled this spring. We have done a lot of empirical research. One of the things we did is we asked non-lawyers whether they were aware that jury trials were disappearing. And most of them thought in the last 10 years, 80% of the people surveyed who are not lawyers thought that the number of trials has gone up in the last 10 years. So there's a disconnect. We can't really get the public to pay attention to this unless we tell them the true facts, that is that public dispute resolution is in danger of disappearing in this country. Judges who do not know how to try cases, and worse than that, lawyers who don't know how to try cases, particularly jury cases. We have made a study of for a period of 6 months last year, we looked at every contract filed with an 8K with the SEC to see what percentage of those contracts had jury waiver clauses or arbitration clauses. Those contracts are the material business-to-business contracts, not the consumer contracts that large companies enter into. And to our great surprise, only 43% of the contracts we examined tried to avoid trial by jury in a public courtroom, which means that there are a lot of companies and and then we began interviewing general counsel to see whether this was accidental, oversight, or intentional. And we learned and are in the process of gaining from general counsel of big companies that they really prefer trial by jury in a courtroom to arbitration today. And that's what they want to use in disputes with each other. We know the use of arbitration clause is designed primarily to avoid aggregate class litigation in our courts. We have done a lot of survey of juries and people who have been on juries. We have hosted full-day workshops at NYU. We have now had over 150 state and federal judges come spend a full day at NYU, off the record, sitting around a table, 30 at a time, and talking about things that they are doing. One of the things I discovered immediately was everything I say is a general statement, not true everywhere. But if you look at the curriculum, which lasts about 2 weeks now for newly appointed federal judges, the program that they did last year, you cannot find jury trials on the educational curricula. Judges are not being trained to try jury cases. And the idea of getting them back to New York and talking with each other from different parts of the country is to kind of let them pick up tricks that others are using. We have maintained currently 2 websites. One is a website called WeThePeopleWeTheJury.com, which is for jurors. Well, the first website is our Civil Jury Project website, which lists our advisors and everything we are working on. And if you go to this website, this is for judges and lawyers and academics. And the other website is called WeThePeopleWeTheJury.com. And this is for people who have recently served on juries to go here. If you've received a jury summons, people click on there, and what we find they're going to the site for is to figure out how to get out of jury duty. And when they click on that icon on the left, receive a jury summons, what they see immediately are short video testimonials from people who have recently served on juries that say, don't throw away your summons. It's the most important experience, meaningful experience you can ever have. And then over there, served on jury duty recently on the far right, they have a questionnaire. And we have collected now over 1,000 responses from people who have been on jury duty who have filled out this questionnaire of asking them about all kinds of things. And the ones that are most articulate and interesting, we then dispatch a videographer and a research fellow from the Civil Jury Project to interview them. And of course, if you click on, and we get people to go to the site, jurors, by asking judges, federal and state, to hand these little cards to people who are on juries as they discharge them. We have them here, and we've sent them to most of the judges in the country. It's a little like a business card. It says, here's an opportunity to be heard. We get the people to have received summons by having an active presence on social media. This is what we use for that. And then we, as I say, we have had, this is our 28th lunch like this. And one of the things over time we've done is collected, we figure the only way to solve a problem is to try to identify the causes. We have identified 18 causes, reasons for the decline in jury trials. One of these is on your table. I urge you to take it with you. Look at it. If you can think of others, let us know. If you think we have characterized some as being very difficult to change, that are comparatively easy to change, then let us know that too. We're interested in your opinion. Our email address is on the copy you have. What we are here today for is to focus primarily on something we can do something about, which is on the right. It's not the expense of we're working on all those things, but what we're working on mainly is to improve the perception of repeat users of the legal system, that juries are reliable, can be trusted, can understand, and can collectively reach a fair result that is better than can be produced either by a single judge in a bench trial or by 3 arbitrators whose opinion will, if they make a mistake, it's largely not subject to review. And so to do these things, to make changes in how we are doing, we got to listen to jurors. And I would now like to, what we're going to do today is we have 4 jurors here, and if all the jurors are here and the judges who are going to participate, we're going to let the jurors go first, and then the judges will go comment on them, what we hear from the jurors. So if the judges and jurors who are here, I hate to rush you now, will come forward and take your place at the head table. While they are doing that, the chief judge of the Northern District is going to welcome us here, and that is Judge Phyllis Hamilton. Judge Hamilton has been a judge for a federal judge for 28 years. And of relevance, most relevance today, she is a member of the Ninth Circuit's Jury Improvement Committee. So she is probably well informed on what the federal judiciary is doing to improve jury trials. And Judge Hamilton, can you come forward and say hello to people?
Well, thank you, Steve, and thank you for inviting me. And the thing that really intrigued me about coming to this event was an opportunity to speak with not only judges and lawyers, who I have quite an opportunity to speak with, but also to interact with jurors. This is certainly a subject that in which I am very interested. And I think that there might be differing opinions, even in this room, about whether or not it's a problem or how severe a problem it is that there are fewer jury trials. But I do think we're probably all in agreement that the jury trial right guaranteed by the Seventh Amendment in civil matters is important. And I certainly would like all the jurors who are here to leave with an understanding that the judges recognize the nature of the public service that you are performing when you perform jury service. So it goes without saying, jurors perform a vital function in our system, our American system of justice, whether it be in state courts or federal courts. Jurors are summoned in for jury duty. They're asked to perform what is really a constitutional duty to settle legal conflicts of some sort, whether or not they are big or they are small. They obviously are disputes that are in need of some sort of resolution and are not subject to simply a bench trial. So from the perspective of the courts, jurors are a precious resource, and we are charged with the responsibility of effectively utilizing jurors, which will promote more confidence, I think, in the jury-serving public. I read something interesting on Steve's website, just as I was trying to find out a little bit more about what they do, but it says that the United States holds approximately 90% of the world's criminal jury trials and almost all of the world's civil jury trials, meaning that there are virtually no other places in the world where civil litigants are entitled to a right to jury trial. That's obviously something that we all have a responsibility to protect and preserve. And I am sure that most of the people here today are interested in doing that. So my interest in being here is simply to be able to commune with you all over ways to improve the jury experience in our courts and the management of our cases and dockets in such a way to give them the best experience possible while also serving the interest of justice. And I also wanted to say, for the benefit of the jurors, and those of you who also might not know this, my interest is twofold, because I am, one, a judge who presides over jury trials, but I am also, two, a citizen that is summoned to jury duty. For those of you who don't know, the federal courts exempt state court judges from jury service because of their status as elected officials. There is no reciprocal consideration. In state court, federal judges are summoned to jury service just like ordinary citizens. I am summoned once every single year and have been for the 30 years I've lived in Alameda County, and at least probably 50% of the time I'm called in. I'm like everyone else. I call in the night before, and sometimes my number is called and sometimes it isn't. And so my interest is in making jury service better, not only for the nameless, faceless citizens who are summoned, but also for myself. So when I go into jury duty, I'm taking notes oftentimes. And I tell you, one of the most impressive experiences I had in jury service, I tell it because I see Judge Grillo here now. One of the most impressive experiences I had, and I thought it was wonderful, I was summoned to jury duty in Hayward. It was a huge room full of people, and while we were waiting, the judge came in and gave this wonderful talk to all of us, and everyone listened to him. And it was a wonderful way to feel connected with the process before you were actually dispersed out to a courtroom. And that's something that I think we should all emulate. Thank you for that, Judge Grillo. That's my only remark.
Thank you, Judge. Actually, another thing we are trying to do, and this is hopefully the first in this community. Hopefully you will decide, you will receive a survey by email this afternoon asking what you thought of the lunch, whether it can be approved, what you would like to hear focused on again. Should it be repeated, how often, and whether the next time you will take responsibility for, as part of a planning committee, to put a lunch like this on. We have now held 5 of these in use. I'm from Texas. So we have held 5 in Houston, 4 in Dallas, 2 in Seattle, and we are beginning now some places where we have had a lunch to come back. They want to do it again. And the next time we do it, it's primarily a local project, and we're available to help you. We also are videotaping this discussion, and it goes, all of the past 27 lunches are on our website, so you can access them all. So now, Judy, would you come forward and help, you agreed to help talk to the jurors. And we ask them each to fill out a little questionnaire and go for it.
Okay, so I think I'd better stay away from that microphone, right? My name is Judy Rothschild. I want to thank you all for being here. Thank you. Sorry if I'm turning my back to you. So actually, I'd like to begin this. We all say that we really appreciate you all as jurors. We have 4 jurors here. Let's give them a round of applause. Now that's pretty good because you haven't said anything and you've gotten a round of applause. So having done that, can I ask you to introduce yourselves briefly and say what court you served in and how long your trial lasted so we have a sense of it, and what type of trial it was?
Sure, I'll go first. My name is Josh Thelen. I served on a jury this past December, actually in Judge Gonzalez-Rogers' courtroom in federal court. It was a civil case.
Barbara Petty. I also served for Judge Gonzalez-Rogers in November. It was a civil case, and it lasted about 2.5 weeks.
Roy Peak, and I served, it's only a few weeks ago, in a civil trial in Judge Cows's chambers, just right around the corner at the Superior Court.
Hello, I'm Mike McGowan. I served on a civil jury in December in Judge Grillo's court.
Okay, thank you. Before we get into sort of the dynamics of your experience, share with us what your first impression was when you received that notice saying that you were being summoned. Anyone?
I'll start again. Sure. I mean, I think like most people, jury summons, there's a certain feeling of dread when it comes in the mail. I had certainly received them before. I'd even gone through voir dire before. This was the first time I was ever selected. But I just want to say, for me, going through the experience of being on a jury was transformational in terms of my view. I never again will feel dread when I get a summons. It was amazing. And I think if anything can come out of this today, it's how do we get more people to understand that every juror in my case had the same reaction. We were amazed. And just briefly, I want to share, one of my jurors was originally she was born in the Soviet Union and was a naturalized citizen here and could not believe that we have this system. It was, for her, truly transformational. So I hope that is something we can think about and discuss in some way today.
I was kind of grumpy when I got the summons, especially I live in West Marin, so coming over to Oakland is not super easy at 8 o'clock in the morning. And we were going out of the country, so I was able to say, we're going out of the country. So they said, okay, and I thought they'd go away. And then they said, how about June? But my son was graduating high school, and I'm like, I can't do it. And they said, okay, well, one more chance. So I'm a CPA, so I said, if you can do it after October 15th, I'll do it. And then they said October 22nd. But it was fine. And I liked the fact that they actually worked with me to make it work, because being self-employed, it's really hard.
Thank you.
So my reaction, I guess, was somewhat the same. Of course, I've received a lot of jury summons and had never been on a jury before. So the reaction is generally the same thing. Oh, for crying out loud! Here's another jury summons, and the concern, particularly when I discovered that it was at the Superior Court, because I know that sometimes those trials are longer, and for a lot of us who are employed by corporations, you can go on jury duty, but they'll only pay you for a week. So if your trial lasts more than a week, then you end up using your own vacation time, either that or not getting paid. So that was a bit of a concern. As it turns out, it was a civil trial and lasted within the week time frame. So that was certainly not a problem from that standpoint. My wife, just about 2 years ago, was selected and served on a jury for the first time, and so her comment once I discovered, yes, I actually did have to go in. She said, "Well, you shouldn't worry if you end up being selected, because," she said, I found it a really rewarding and very educational experience." And I have to say that's exactly what I found it too. It was enlightening in many ways, and I'm certainly glad that I did, and I will receive, I guess, future summonses with a little bit different outlook than I did this one and previous ones.
Well, when I got this summons, I just checked my schedule to see how that would conflict with anything else that I had made commitments for. And I'm always happy to serve on a jury. I've mentioned a couple of people already today. If I were ever on trial, I wouldn't want to have the jury made up of people who couldn't get out of it. And so, I've been on a half a dozen juries, civil and criminal, and it seems like I always get picked for some reason. I haven't learned how to fill out that questionnaire properly, I guess, but I've always learned something about the nuts and bolts of the case, and also a lot about the people who are on the jury. The first jury I was on, I had no real expectation that this motley group of people was going to come to, the rational decision, and I was amazed. There's so much collective wisdom, even though it's coming from very different perspectives, that somehow this weird system that I don't know if anyone would design it from the top down, it really seems to work. So I've always felt rewarded, not just from learning things personally about the facts of these cases, but also participating with other people who had chosen to participate and could share their perspectives on what was happening.
Okay, well, thank you all. What stood out to you in terms of the trial procedure, the actual procedures? You were all in civil court in this most recent experience. What stood out to you that was either frustrating or really positive?
I'll take a crack at that. I think so much of our legal system, especially for jury trials, is supposed to be for the jury. We are the ones, after all, making the deliberations, making the decision, and yet so much of the case is shrouded in mystery and secrecy. And I understand some of that's by design. We can't really know too much in order to remain impartial. But it's so many times in the trial, I think when we went back in the jury room, and as much as we could talk about it, which we couldn't, but we kind of could say, man, this is frustrating. Like, what are they talking about? What does that mean? And I'm not sure. I have no easy answers for that. But I think that was a general feeling amongst our group, that we just so often didn't know what was going on, and that was frustrating.
This might be kind of in the same line. A lot of us would have wanted to know the law in the beginning, so that as we heard the case, we could be thinking about whether or not this was a breach or not. And it's probably by design that we didn't know the law until the very end, but that was a little frustrating because I didn't know what to think, and the rest of us kind of felt the same way. It was also frustrating, one of the parties seemed not to be very prepared, even though they theoretically had been working on this for years, and some of our jurors were just looking at each other like, really, this is what you got? So that was a little frustrating.
I think one of the things that surprised me a bit during the proceedings was there seemed to be some segments where one of the attorneys went into what I thought was an excessive amount of detail, in some cases kind of repeating ground that had already been covered once. And I couldn't help thinking, So why are we going over this again? I think, we kind of understand that part of it. It seemed like a disproportionate amount of time spent on some topics that maybe didn't appear to be as important, or in fact that I think we already understood kind of what was going on in that particular situation. The major frustration for me actually had nothing to do with the trial itself. It's just strictly the logistics of getting from the East Bay to this courthouse. Just because of the difficulty of transportation, the only way that you can park next to it is to get there at 7 o'clock. And of course, when the trial begins at 9, that leaves this big gap. Taking BART is somewhat the same issue. My 3 possible parking spaces were either Castro Valley or the 2 Pleasanton sites. Those lots are all full by 7 o'clock. So what I ended up doing actually was parking at where I work in Pleasanton and walking 3 blocks to the BART station. That at least let me get in at a reasonable time. Otherwise, I couldn't see any way to get here, some other than well over an hour before I was actually needed, if not 2 hours before. That actually for me was the largest frustration of the whole experience.
Well, I would second that. The transportation is a big issue. Just recently, and it seems like it's going to be getting worse. I know Alameda is a very large county, and some of the trials are far from where I live in Berkeley. And I know my wife is very reluctant to respond to jury summons if it's going to be somewhere that will take her hours and hours. She doesn't like to drive, but just to get to and from. And if that's unavoidable, then maybe there should be some recognition of that and better compensation for the travel time or the travel expenses.
Let me ask this question. Thank you for your comments. I've heard all these before. One of the things, Ms. Petty, your jury, your trial, the judge did something very innovative and conducted the trial from 8:30 in the morning to 1:30 in the afternoon. Mm-hmm. Now, that's one of the innovations we are going around the country asking judges to try, because the jurors that we talk to love it. The lawyers actually like it pretty good too, because it gives them the afternoon to not only take care of other business, but to get prepared for the next day. And the jurors love it because they can do their business.
Yeah.
So you were on 8:30 to 1:30 with no lunch break. You
Correct.
just kind of a snack break or something, right?
Right, and I have to say that we all kind of appreciated that. On the other side of that, she wasn't letting anybody off the hook, because she said, "You're getting out at 1:30. I don't want any excuses." But we all appreciated that. And also we missed all of that terrible afternoon traffic getting out of Oakland and to where we were going.
On the positive side, since I asked what was negative, what was positive, what were some of the positive experiences of serving as a juror? Or how you were treated by the court, sort of the gamut?
I mean, as far as treatment, I mean, everyone was extremely professional and courteous, for sure. I guess the most positive thing really was in the jury room during deliberations. It was just this disparate group of, and it turned out to be 8 jurors, even though it was a civil case. I understand you only need 6, but we had 2 alternates. We didn't know we had more. But just for this group of people to come together and find consensus was incredibly rewarding. And we had some pretty strong disagreements at times, and it looked for a long time like we were not going to be able to agree, but we were able to work through those differences and those strong opinions and come to consensus. So that to me was my biggest takeaway. But as far as the experience with everybody from the time you entered the federal courthouse, nothing but professionalism and courtesy. So.
Yeah, I would agree. I think our group of jurors, I mean, I could become friends with these people. It was amazing how much quality these people had, and everybody respected each other's opinion. On breaks, we actually laughed and had good times. And I'm wondering if that was partially due to the voir dire process, because in the trial I was on a long time ago, you got called up one by one, and it was a lot of wasted time. And what we did this time is we filled out questionnaires that were related to the case, and then the attorneys looked through them, and then I think it was only maybe, I don't remember what the first group was, but it only took 2 times to get the jury together. And I don't know if that's how we got that good group together, but that was a good experience. And I also felt very respected and appreciated by the court and the judge in particular. So that was a good experience.
Yeah, I have to agree with that. I think the message that the courts appreciated our time and our service, that came through loud and clear throughout the whole process. We were also on the 9 a.m. to 1 or 1:30 schedule, which was a great help as far as not making the process too disruptive. Beyond that, just the experience of seeing how that legal process actually works, as opposed to the kind of made-up version that you see on TV, that was pretty enlightening in itself. So yeah, it was an enjoyable experience in many respects.
Thank you.
Well, I already mentioned that I enjoyed learning about the facts of the case. It was usually in a different field than I'm experienced in, and also the participation with the other people. But as far as a suggestion goes, for the new jurors, the people who haven't been there before, it's really helpful to have the procedure explained. And it may be boring and old hat to the attorneys and the judges, but to the jurors, they're, kind of like a deer in the headlights. They aren't quite sure what's going on. They want to fulfill their responsibility. So take opportunities to educate people in the process, what's actually going on.
Go
Let me
ahead.
ask just a few other questions. In any of the courts, did you get at the beginning of the case instructions from the judge about what to look for and what were the elements of the claim? I mean, substantive instructions, not just on the burden of proof, but
What we call pre-instruction about the case claims and what was going to be at issue.
and what you have to prove and what to look for. Did any of them, you didn't get that at the beginning? Would you have liked it at the beginning? On the end, I mean, you said it would have been helpful, I think.
Yeah, I mean, I believe we did receive instructions at different points. Certainly right before we had to decide an award, we had a lot of detailed instructions. At the very beginning of the case, I don't totally recall exactly, but I feel like the judge did a pretty good job of keeping us up to
Were
speed.
any of you allowed to ask questions of the witnesses?
Not directly, but like on paper.
On paper, submit a question.
Yes.
It will go to the witness.
Yeah.
And we did that. I was the foreperson, in fact, so we had to write it on the official form, and we
Was
did
that helpful?
A few times. The act of it, not so much. I mean, getting an answer at least was.
Yeah, I'm not asking about was it helpful to write it. I'm asking was it helpful to obtain some information that you were asking about.
As much as the information that we did get, yes, that was helpful. They couldn't tell us very much.
One of the biggest complaints we get from jurors in the questionnaires as well as these lunches is the lawyers repeat themselves too much, and the trial lasted too long. They could have decided it earlier. So I think one of the reasons that lawyers repeat themselves is we don't know whether we're getting through. So you just repeat yourself. But the questioning does help the lawyers know what they need to focus on. But you were all allowed to submit questions to the witness. That's great.
You all probably heard opening statements before you heard the evidence, correct? The attorneys got up. Did you feel that you made up your mind after the opening statement, or did your you need to hear the evidence before you actually came to an opinion about the case.
Definitely, I felt like I had to listen to the whole case. And there were different periods of time during the case where I was like, oh, I think I'm going this way, and then, oh, I think I'm going this way. So, you really have to wait until it's all done and both sides have completed their cases before you can make a decision, because you never know what piece of information is coming up that completely turns around your thinking.
Mr. Thalen, you're nodding.
Oh, absolutely. Same way. I felt that. I think all of us, after the trial was over, we could go back and sort of compare notes, and we all said something to the effect of, on one day we were leaning this way, and then the next day, switched. So we did maintain, I think, our impartiality is pretty well, and really, once we got into the deliberation room and actually had the exhibits, we as a group really poured through those and talked about a lot of things and made a huge timeline on the wall and tried to make sense of it as best we could. So we were grateful for that opportunity as well.
Well, comment on submitting written questions. I thought that was helpful for the jury to focus on specific things to get into, because when you have 12 people in a room, I think that's near the critical mass where nothing can ever get done. And so that helped people to focus on specific things.
Yeah, as far as the other process, I think based on the initial arguments, I was at that point completely unsure about whether I was leaning one way or the other, and it really took just the development of the testimony and the evidence to ultimately, and it wasn't entirely like from middle to one direction. It was wavering back and forth a few times as more information came out.
Was there anything that you think would have been helpful to you, that would have helped either your understanding of the case? You mentioned earlier something about sort of what the topics were, but what else would have helped?
Well, and this is really something that relates more to the specifics of this particular case. Certainly, I'm not quite sure how to describe this. Had one bit of evidence been, I'll say, more quantified and less subjective, that would have helped. A lot of the decision was based on photographs of a location that were not actually clear enough to support one way or the other. So it left everything. As the trial went along, I kept thinking, well, okay, so now are we going to see a photograph that actually shows what's really pertinent to this, and that never did happen. That would have helped, but then I guess that had nothing to do with exactly the process of the trial itself. It was just the case that that wasn't available.
What kind of graphics were used or demonstratives in the trials that you served on?
In my case, there were a fair number of photographs.
One thing that would have been helpful to me, and I was able to move seats, but I was sitting in the back row, so there's 2 rows of jurors, and there's a monitor on the front, but there's not a monitor for the people in the back. And this case had a lot of numbers and percentages and graphs, and I was having a really hard time seeing it, and so the judge let me move. But I kind of think that everybody should have the ability to see those monitors as clearly as the other one. So I think that would have been helpful.
One of our frustrations was there was a lot of deposition transcripts and excerpts shown, and both sides had very different technology and styles on how they wanted to present it. One attorney had his iPad that he could plug in and did everything himself, and the other side had sort of a dedicated document person who was at a laptop, and just getting the technology to work at sometimes was a comedy of errors at times, and it definitely slowed things down. So I don't know what the answer to that is, but we just wish that could have been a little more streamlined. Just things worked the way they were supposed to more quickly. So you're just looking at hundreds of pages of deposition transcripts. It's a little hard to stay focused sometimes when it can't even pull it up on the screen.
We have, is someone in the audience wants to ask a question, please do. Judge.
Is this on? Great. Okay.
Yep.
I want to thank Civil Jury Project for having this lunch. I really want to thank these jurors. My name is John Tiger. I'm a judge on the federal court. I was on the Alameda court where some of you served as jurors for 11 years before that. And jury trials are my favorite thing I do, and my favorite part of that is jurors, honestly, because it's delightful for us to get to meet you and work with you, and I'm glad you had such a positive experience. I just want to ask about a couple things, and if you could just raise your hands, all four of you, if these would have been useful to you when you're doing your jury service. One thing that some judges do is they pass out notebooks, and they don't put all the exhibits in the case, but they get the lawyers to agree on the 5 or 10 or 12 documents that are really going to be core in the case. And they go in the notebooks, and the jurors just have those throughout the case. Would that have been helpful to you in your trials, do you think, as jurors? Okay, so is it Thielen?
Felon.
Mr. Thielen is a yes on that. And then the other thing that's similar to that is sometimes they pass out a sheet that has photographs of the witnesses. They're going to testify in the case, and you have those photographs with you as kind of a mnemonic. And some people say it helps you remember the testimony given by those witnesses, and they bring that back with them in deliberations. Would that have been helpful to any of you?
We had that. So
You did have that, and was it helpful?
Yeah, it was very helpful.
Okay, good to know. Thank you. And the other thing I want to say, Steve, is I have been trying only from 8:30 to 1:30 since I moved to the federal court. Every trial I've ever done. It's been great. My jurors have loved it. And if any judge ever wants to call me and talk to me about it, please give them my number.
Great.
And thanks again for this lunch.
Oh, yeah. Terrific. Yes, sir.
Well, I'd just like to comment that what I've said today were my opinions, and this is a very small subset of all the possible jurors, and we served in a certain court, and we had a lot of things in common. I think that you really need to get a broader database of jurors to get more evidence to work with.
Well, that's what we're trying to do with all the questionnaires, getting questionnaires back and trying to get jurors to come to these lunches and tell us. But the experience, what we hear is very similar at these things. The judges here, we have judges here that are listening to you too. And by the way, the judges, do you have any questions for these jurors that you want to ask them now? Because it's a good opportunity.
Well, I wanted to ask, are there questionnaires that we can give to our jurors? I have thought about doing that and have not quite gotten it together.
We have developed, with a lot of input from our judicial advisors, a questionnaire called a juror feedback form that we urge judges to hand to the juror at the beginning of the case. Because what we find is that if the jurors know they are going to have an opportunity to comment on what they have observed and to fill out a satisfaction survey or a comment survey, they will sometimes take notes and remember, because one of the difficult things is remembering what happened in the trial with any great detail. I mean, you can remember how difficult it was to get through the traffic to the courthouse in the morning, but memories fade. So that's one thing and we will make them available to all the judges. We try to send them out. All of our judicial advisors have received that questionnaire. Some judges don't want to give it to the jurors at the beginning, but they will give it to them at the end of the case. So it's just, yes, we have it, and we get great information from jurors that way. One of the things that we have talked about, and it's hard to get much traction or feeling about it because I'm not sure it can be done in state court here. It can be done in federal court. The judges probably tell you in the case that you are not to discuss the case amongst yourself until you are all together at the end of the case and you deliberate. Now, some judges around the country and some states allow jurors to talk about the evidence when they are together in the jury room without deciding. You can't vote, you can't decide who wins, but you could say, did you hear that last witness? Did he ever say what happened on Sunday night? boy, that last witness didn't have a very good memory, did she? I mean, things like that, which people naturally tend to do. Most people follow the judge's instruction not to discuss the case, but would you have found it helpful, for example? By the way, do you know why you're not allowed to do that?
Can I follow up on that? Because I've thought about it.
Yeah.
And in particular, I've got a couple of my jurors here. The December trial in particular, there was a lot of, you guys deliberated for a long time. My concern with that approach has always been that the defendant doesn't get to put their case on until after the plaintiff. And so I'm always concerned that if I allow that to happen, you get those strong opinions and strong personalities early, and it may set people in before they get to hear the other half of the case. And so it may not quite be fair, which is why I've not done that kind of thing. I'd be just curious what you think, given the nature of the deliberations, without telling me anything specific.
Of course, I think for the most part in our situation, it was really good that we were not able or allowed to talk about it until everything was over, because there were some dominant personalities in that jury room, and I think had those voices been heard earlier, that could have definitely influenced other people. And we were really good about not talking about anything about the case until we were allowed to in deliberations. And that was part of that transformational experience I mentioned earlier. It was very serious and, quiet even during the case itself in the jury room. But when we got to finally talk about it, we really opened up and we're quite passionate about it. And I was grateful that we hadn't had any of those personalities kind of emerge yet until that time.
Yeah, I think that's good, especially if the judge explains to the jury why it's being done. And then they'll understand that, oh yes, we have to wait for the other shoe to drop before we start deliberating.
Well, I recently worked on a case in Indiana where they allow jurors to talk about the evidence and the case throughout the trial. And it wasn't so much strong personalities that became the concern. It was that people started to form opinions that they started to form before they heard all the evidence. So.
And you combine that with a strong personality, and you can imagine that could influence others.
Was there, yes?
There are some, Steve, there are some interesting, innovative ideas that are coming
Gary.
to make our communication with jurors better. And one of them I really like, and I've urged some of the judges to do this, is to allow the lawyers to take some of their argument time throughout the case and stop and turn to the jury and say, all right, this witness was important because of this, and we're going to tie this in, and just take a couple of minutes to be able to do that. Both sides get that opportunity rather than throwing it at the jurors in these long discussions afterwards. So I think this kind of innovative thinking is going to be helpful to us to make jury trials better for all the parties. It's the kind of thinking that I hope you're working on, Steve, in this great project. Thanks.
Gary, have you seen that done in state court yet? That's over here. Have you seen that done in state court yet? Have you seen that done in state court yet?
Judge Friedman was trying to do a complex litigation, and we were ready to go with it. One side didn't like it, I did, but it was definitely on the table, and it has been something that I think you need to think about a little bit, and lawyers need to be thinking in a more innovative way about how we can do better communications. Even though I'm an old lawyer that's been doing this for a long time, I think it's important that we do this as we update the technology and the way we try cases.
Yes, and now let's turn to I think we should turn to the judges for...
Is it one last thing?
Can I just say one more thing about that? And I think it's important, though, that you have the roles distinguished. The judge has a job, and the attorneys have jobs, and the jurors have jobs. And I think it's important to keep those distinct and not, let the judge dominate or summarize things as he sees it or as she sees it. I think the roles are important.
Okay, well, thank you very much. think you can tell we all appreciate your comments and your attendance here. So you started with a round of applause. You probably can get a second one.
And now let me ask the judges for some feedback. My first question to all of the judges is, do any of you think that jury trials are disappearing because they're too expensive? Does anyone think that's one of the reasons?
Why is that not on the list? That seems like.
It is on the list.
Is it?
It's on the list. It's on the right column. It may be the first thing on the right column.
Expensive discovery.
Well, discovery. But let me ask you this. The discovery in a bench trial is just as expensive as in a jury trial. Bench trials typically, in my experience, go on for much longer than jury trials because the judge will try 2 days this week, 3 days next week, go on vacation for a week. After the transcript's done, the judge gets a transcript, you come back and make an argument. 2 months later, you got to learn the whole case again. I'm not sure, and we see the bench trials are going down quicker than jury trials, so it's hard to say that it's expense that's driving that. I think it must be something other than expense. Now, one of the problems with jury trials that makes them more expensive is that typically there are more preliminary hearings about what the jury's going to be allowed to hear. The motion in limine practice has gotten very lengthy in this country, trying to keep the jury from hearing some things. But other than that, what do you think, Judge Grillo?
I don't think expense contributes to it. I think your observation that a bench trial is as expensive as a jury trial in terms of the discovery is probably correct. I don't know why they're declining. I'm just very sorry they are.
Well, they're declining. Take a big picture. For 40 years now, our country has been of the school that litigation's a bad thing. If you ask people what word they associate with lawsuits, it's frivolous. Most people in the country think litigation is frivolous because we have been brainwashed to think that. And from managerial judges who give credit, the metric that you're judged by is how quickly you dispose of your case, how much backlog there is. No judge you can't even get the statistics. I cannot get the statistics today in your federal court, Northern District, or probably not in the state court, of the judges. How many days or hours did you sit on the bench with a jury in a jury trial? Why don't we look at that? You're trial judges. Why aren't you, why doesn't that fact look like, Judge?
I wasn't going to answer that question. But when I was a state court judge, like Judge Tiger, I was on the state court before coming to the federal court. I set 5 trials a week in my department. And every week I was in trial about once a week. 4 would settle. So 4 out of 5. That wasn't me. Those were the lawyers, right? And so part of it is that if you have reasonable people should be able to figure out how to resolve disputes. Many of the cases I tried as a state court judge I was trying cases where the lawyers had lost control, where the lawyers didn't understand whether their witnesses were very good or not. This goes to your point about, are you a good trial lawyer? Mm-hmm. First witness up, and I'm looking at this guy thinking, are you kidding me? You didn't understand that this person was going to tank your case? And I've had lawyers say, well, Judge, I've put $100,000 into the expert. I said, the jury doesn't know that. Right? This is just, part of it is bad judgment, I think. And maybe it is also that we don't have, there are some judges who aren't moving their dockets, who aren't getting people to trial. But But, they go out in federal court, we're
Pardon?
setting them. You have the opportunity if you want to go, but people make economic decisions to resolve their cases rather than have a group of strangers resolve them for them.
Can I just say something?
Yes, Judge.
Along the same lines? Everything that you've given up is sort of charged with this judgment that cases resolving short of trial is somehow a bad thing. And I would just offer a different point of view on that. It's not just about the expense. There are a lot of reasons why cases are settling and or resolving in other ways. It's not, all cases are not having summary judgment granted against them. In our court, 98.6% of civil cases settle through one of the various different alternative dispute resolution options that are available in our court. And I think it boils down to there are two schools of thought. Are trial judges responsible for trying these cases, or are we responsible for resolving the cases? I frankly belong to the latter school and think that my job is to resolve the cases, and sometimes settlement is superior to a jury trial. And that's because, as one of our jurors has said, the jurors think that a lot of evidence is being kept from them, and we all know there are evidentiary rulings that are made that supports that conclusion that he's drawn. In a settlement or a mediation or an early neutral evaluation environment, sometimes the parties are able to learn more about their case and their opponent's case than they would in a court of law. And what they learn provides an incentive for them to come to a mutually satisfying resolution. And sometimes that's just superior for both sides to feel like they've participated, they've been heard by whoever the neutral is, and they are agreeable to resolving a dispute. I don't think that's a bad thing.
No, I didn't mean to imply it, and that's where there are a lot of things on the left side of the chart that we really can't do anything about. Civil discovery has made it possible to figure out what your case is all about before you go to trial. I mean, that's Professor Langbine at Yale says the reason trials are disappearing is that we pre-try the case. I mean, we in discovery. Others are saying Judy's industry, the mock trial industry, where everyone mock tries their case. We are in fact trying the case. These big complicated cases, they get tried because both sides are doing multiple mock trials by very qualified people, and if they do it right, they're getting very similar results. Once you do that, it's kind of a trial. You know what the case is worth. But certainly, I think there are some times that people are forced to settle because they can't get a firm trial setting, or the trial setting is too far in the future. Justice Gorsuch said that 90% of the cases that are set for trial in this country get continued.
I don't know where he gets that.
I don't know where he gets it.
Not true in my
But-
court.
Not from Judge
Not
Rizzo.
true.
But I mean, I don't know where he
Not
gets
true
the
in my court
figure.
as well.
It's not footnoted. And what we're trying to do is just make the trials that we do have better, which is something we can all focus on.
Can I make a comment? I mean, there's things that are coercive, such as having to sign arbitration agreements to get a job, and frankly, the cost of trial, which I don't know how you could possibly ignore. These experts cost an incredible amount of money. Lawyers cost money. When I had a client, do you want to go to trial? I'm going to need a $500,000 retainer, or whatever, $200,000, whatever it is. I mean, that discourages trials, I think. And then there are facilitative things like Judge Hamilton's talking about, settlement conferences, forms of ADR. And if people can reach, we want to keep jury trials alive. We want the public involved. We want lawyers to know how to try and judges to know how to try jury trials. But if you look at an individual case, a traffic accident on the Nimitz, it's good that it gets resolved at a settlement conference and that we don't have to inconvenience a jury panel of 50 people to come in and spend all that time and money to come to an equivalent result. So I think you have to look at it both ways. There are things that are bad where the right to jury trial is taken away, and there are things that are good where disputes are resolved in constructive ways and people get on with their lives. That's my view.
That's an excellent point.
I don't buy that lawyers all want jury trials and they're frustrated. We put into effect in California an expedited jury trial process, which was an abysmal failure. No one wanted expedited trials. They wanted a chance to pre-try the case, to do the discovery and go to ADR, but we had very, very few of those, and people don't want them.
Do you think that part of that may be that fewer and fewer lawyers are actually have experience trying cases, that it's hard to train a trial lawyer these days, because no longer can you learn by sitting at multiple, like I did, sitting second chair or third chair, where really capable lawyers were trying cases. We don't go to, the American Board of Trial Advocates has to change its rules because you can't find people that have tried first chair 10 cases to verdict. Hard to find them, qualified people.
Well, I do think that training of judges is important. I had one very seasoned litigator tell me that, it matters when judges know the rules of evidence. It matters when judges know how to try cases. Because those who had been around for a long time, they get newbie judges who haven't been trained, who do not know how to manage their courtroom. And that's really frustrating for the parties. And so he said, I cannot in good conscience tell my client to go to trial in front of a judge who doesn't know how to try a case.
That's a problem, of course. Let me ask the jurors, back to you a moment. Did you think that the attorneys that were in your case on both sides, do you think they were equally matched or not? And did it make any difference in the result? Yes, sir.
Well, one thing I just want to say about that is that once the trial was over, Judge Gonzalez-Rogers came back and talked to us and answered any questions we had about, and I don't know if that's common practice, but it was so welcome. It was a great way just to wrap it up, and perhaps that can only happen when it is, we're unanimous on all the claims. But I do think the attorneys were evenly matched. We did learn in that conversation with the judge after that, on one side, one of the main attorneys who actually did most of the cross-examination, what have you, was brought in like the last minute because she had more trial experience than the plaintiff's counsel. I think the original counsel just had not had much experience, so they had to sort of bring in a ringer here at the last minute. And it was a good thing too, because had that person not been there, then I think it would have been very uneven. So having that gravitas, that experience in a courtroom, in that case was very important.
In our trial, one set of attorneys seemed to be much younger and less experienced, and it was a little frustrating. Some of the younger attorneys they brought up to speak at the microphone mumbled, we couldn't understand them, or they got flustered and they had to go back and talk to their people and then go back up to the mic. And then the other set of attorneys seemed fairly well established, and they were very efficient with their witnesses and what they wanted to say.
Did that influence the decision, you think?
I don't think it influenced the decision, but we definitely knew who knew what they were doing.
Okay. Yes, sir.
And they were right, by the way. And they were right.
In my trial, it was obvious just because one of the lawyers was pretty close to my age, and one of them was probably younger than my kids. So clearly there was some level of experience difference. And I'd say the younger fellow was a bit less organized, I'd say, in his questioning and so forth. But I don't really think that had a significant impact one way or the other as far as the decision went. I think it made some parts of the process go not quite as smoothly as they might have, but otherwise it wasn't. I was actually somewhat surprised to find out after the trial that neither of the attorneys had tried a case in court before. In the case of the younger fellow, that wasn't too surprising. A little more surprising in the case of the fellow who was closer to my age.
How about experts? Did you have experts in your case, expert witnesses?
Yes, we did.
Did you think the experts made a difference in the outcome? Or did they just cancel each other out?
I don't think they made a huge difference. One, of course, now my own particular bias is one of the experts was a registered mechanical engineer. I'm also a mechanical engineer, and he was commenting on a civil engineering item. So my thought was, well, okay, I'm not sure exactly what makes this fellow an expert, certainly not the training, other than the fact that he had worked in these sort of cases before. I wouldn't say, other than they did bring up some points of regulations that were useful to know. Beyond that, I don't think they had a huge influence one way or the other.
All right.
We only had one expert on our trial, a forensic economist, which none of us really even knew was a thing. But I think it did help us because we had to decide damages on emotional distress, and there are, of course, no parameters. So at least we had something to kind of serve as a starting point based on her testimony.
We had one for each side, and I'd say neither one of us impressed us, other than the amount of money that they were probably making.
All right. When you went to deliberate back in the jury room, did each of you have a copy of the judge's instruction in writing? Do y'all remember? Did each of you have a copy of the verdict form, or was it only given to the foreman? The questions that you had to answer.
I believe we all had a copy, and then there was the one official, form. But we all had binders with all the instructions. It was very organized, and then we had, of course, all the evidence as well.
You began by saying at the beginning of this discussion that there were things that you wished you had known. Could you give us some examples? And also, did you make any effort when the trial was over to go to Google and find out what those things were so you could identify what they were?
Sure, I'll answer that second part first.
It's totally okay.
A little bit, yeah. Once it was over, sure, I went back and read about the trial and did try to answer some basic, I guess, questions about the law. But to an example, without getting too specific, when it came time to decide on damages, we learned after we had decided on the 5 claims in the case, right? And so we decided on the 5 claims, and then we went back in the courtroom and were told, okay, now you're gonna deliberate on damages. And it was at that point there was a lengthy debate between the two sides, and we learned that basically one of the things we decided could not even be considered because of some, to us, rather arcane bit of law. Had we known that prior to our deliberations on the claims, I think I'm not saying it would have necessarily changed them, but it certainly would have changed the conversation if we had known how to read the law particularly. Once we understood what was going on, we go back and we could kind of read between the lines, but none of us were trained in the law, so beforehand we weren't able to make those distinctions. So that was something that really frustrated, I think a lot of us in the room.
All right, we're 5 minutes beyond the cutoff time. Does anyone in the audience have any questions to put to either the judges or the jury?
I have a question.
Yes.
Joe Satterley, for the jurors, was there anything in particular with regards to the presentations of the lawyers or technology that you found to be particularly useful, whether it be visual animations or anything like that that stuck with you, that made it more persuasive in the presentation of the evidence?
I would say that when they put things on the monitors and then they highlighted certain excerpts and brought them up bold and in a different color, that really made a difference to what we were actually looking at. So that was helpful.
Did you have any video depositions? Did any of you
Yes,
have
those were painful.
painful?
Yes.
So one of the things that I discovered happening in the country, you know, I'm learning all kinds of things. I've been trying cases for 50 years. Is that lawyers now are beginning to take these depositions using 3 cameras. 1 camera on the witness, 1 camera on the lawyer asking the question, and another camera on an Elmo where the document is being displayed. And to watch that is so much more pleasurable and interesting and engaging than to watch just a speaking head. Because, you know, when you go to a movie or see it on TV, a trial, you see both the lawyer asking the question and you see the witness responding. That's the way we see things in life, and that's kind of what people are used to. It's terrible to just have to watch the witness with...
And reading is even worse.
That's even worse. Thank you very much for coming. Jurors, thank you for being here. And thank you, judges.